Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press. We did review Bank Failure, which is about lessons from the Lehman Brothers matter. But this book is called The Law and Practice of Restructuring in the United Kingdom and the United States, now in a second edition. And it's a useful complementary book in some respects because we are looking here at financial law, banking law. We're looking at the way in which we are dealing now with a global community and with comparative law issues in probably a rather different way from many of us than many of us would have imagined. Now, this book itself, as I say, Law and Practice of Restructuring in the UK and US, second edition, has been edited by Christopher Mallon, Shai Waisman and Ray C. Schrock. Now, the book is it's a complicated book. It's not a book for someone who has no knowledge of the issues within the financial industry. We've given it the title taken from the book, Melting Ice Cubes. Comparative lawyers on both sides of the Atlantic will love this definitive text on a crucial area of law. Obviously financial services. Now, what we're going to be looking at is the book first of all. It's a hardback, green cover, there it is. You can see the spine, there's nothing on the back. Now, we've got inside, we've got an index. The index is by paragraph numbering. You can see there, quite very much the house style of Oxford University Press. You can see the structure there at the front of the index. Then we get into the book itself. You can see the paragraph numbering is in the margins, and you've got the actual footnoting at the bottom. And a lot of footnoting, mainly the articles, mainly all the authoritative information to go with the assertions made. There's the front page there, and then there's the detail from OUP, and there's a very nice little well, in fact it's actually dedicated to a number of people, and you can see it. I'm not going to read it out, you can see it there, and it's worth reading because it's people there thanking. Then you've got the preface itself, which is well worth reading. Then you've got an introduction, introduction to the table of contents. You can see the names are listed so you know who's written what, which I also think is helpful when it's an edited job and you've got a lot of people who are involved in producing the work. You can see we run through the chapters there, the contents section there. Then you get the 14 chapters in total. To each chapter, basically, there's a conclusion, which again, so it's a nice logical structure. You've effectively got the introduction, the middle bit, and then the conclusion to each one. Then you've got the table of cases. You notice how they are structured by country, so that's quite helpful. A lot of cases. Then legislation as well, same way of doing things. Then the very substantial list of contributors. A lot of people involved in this. You can see, I can't mention all their names, but there's a little, for each one, there's a little biography. So you've got some idea. It's alphabetically listed, but you can see a large number of people have contributed to this. Then there's the introduction, which sets out what this book is about. They're basically updating the introduction from the first edition. It says, as we said in the introduction to the first edition, as continues to be the case, two systems of law dominate the world debt markets, English law and New York law, and that is the starting off point. Then we go to chapter 2, which shows you then have a little index for the chapter, which I think is quite helpful because you should be able to find things to navigate quite quickly, because this book is a bit daunting because you're just looking at it, you've got an awful lot of authoritative information based on acts of parliament and all sorts of rules and cases. So it is not something that one will pick up initially, but once you get into the subject, like everything to do with company law, corporate governance, whatever area you're involved in, the initial approach, it looks, that's tremendously complicated, but when you look at it and settle down a bit, you'll find that it follows a logical structure, so you should find what you're looking for. So what do we say about the book? Elizabeth wrote the main review and we had a long discussion about it. Financial services being a crucial area of endeavour for lawyers on both sides of the Atlantic. This new newly published title from OUP, should attract widespread interest, not to mention shouts of welcome from comparative lawyers practising in either the United Kingdom or the United States, or both. When I say the US, I'm talking about New York actually here, but we'll get on to that. This is the new updated edition of what has become a definitive text first published in 2011. And as the three co-authors remind us, English law and the law of the United States, specifically New York, continue to dominate world debt markets. That's the beginning of the introduction, and it's repeated because that's the essence of this book. Quote, any company of any size operating across borders, they add, will almost certainly have debt governed by English law and New York law. And where peaceful coexistence reigns between the two, they run hard up against each other where a company faces stress or de-stress. And it's truly odd, therefore, that there's been apparently no law text except for this one that has enabled practitioners to identify and activate solutions to the myriad problems that bedevil a distressed company operating transatlantically. And this is the only legal text around which, as the lawyers explain, is the first attempt to grapple with these issues from both an English law and a US New York law perspective in one single volume. And that's what you're getting here. So again, it's very much what we're looking at in the future now with a lot of our publications, the fact that it is no longer very, very localized in terms of jurisdictions. You're talking of a much wider global jurisdiction. In this case, it's actually England and New York. Now, read, for example, and it's only one example, a chapter on emergency sales in the UK and the US. Here is an illuminating perspective on the similarities and major differences between these two jurisdictions in the handling of distress sales. And distressful and complicated they are. As is pointed out at least twice, any business that relies on confidence in its financial position, its brand name or goodwill, will be particularly hard hit by suggestions that it is or may soon be experiencing financial distress, so say the authors. Now, likened to melting ice cubes, an interesting piece of imagery, I must say, suffering from the heat of pending insolvency, such companies lose customers and counterparties all over the place as their reputations become ever more tarnished. The methods for carrying out the emergency sales which may result, and which vary significantly between the US and the UK, are discussed in succinct but pertinent detail, with the reasonably optimistic note that such methods can present an effective means of preserving value in either country. Further discussed are any number of issues relevant to restructuring, from, for example, the duties of directors and management to shareholder claims, to employees and trade unions, particularly relevant, I think, in this country. But of course, do remember they have unions in America as well. To pension scheme trustees and regulators, to specific cross-border issues, and much more. Now, let me conclude by saying here is an authoritative and highly regarded text which contains a wealth of legal expertise presented by, in addition to the authors, 35 expert contributors, all of whom offer the benefits of their extensive experience in this field. It's highly readable, easily navigable, and copiously footnoted, and it's a handy and helpful volume in our view, which belongs in the library of every transatlantic practitioner. And the publication date is cited at 2017. It's certainly a book which I think is well worth a read if you are involved in debt restructuring and actually in the wider areas of the financial market. We're in a new era with Brexit, and we don't know what's going to happen. It really is a jump into the dark, and I think this book itself will be very helpful when it's looking at the restructuring issues in the UK and the US, in other words England and New York. There's the book again, there's the spine. Now, just opening it in the middle, what you've got here, you've got a case study, which is quite useful because, again, this is aiming to be quite practical, as well as giving you the statements. You've got various case studies listed here. Just running through, this is just the middle of the book. You can see the structure again, there's a lot of footnoting, but the case studies are important. And then of course you've got very much at any given time a specific statement of whether it's UK or US, and this is the United States, of course, this side. Then you've got, again, I mentioned trade unions, employees and trade unions in the UK. Now, just the final point, that's TUPE based information. Can I just say that we are in the middle of a general election at the moment in the United Kingdom when I record this, and there may well be some changes to trade union rules, all sorts of rules concerning employers and employees in the future. It doesn't really matter who's in power, I'm sure there will be some changes. So whilst we've got the second edition just out, I don't think it'll be too long before we get another edition. And that's going to be the same with, I think, quite a lot of books at the moment, where we don't quite know what's going to happen in the future. So watch this space. In the meantime, a big thank you to everybody at OUP and all the people involved. You make our lives easier by producing these books, and you are giving us a great deal of food for thought. So thank you. Bye-bye.